Cianciollino from the University of Milano Bicocca, Anna Patrick from the University of Basel, and Natalie Klein from the University of UNSW, University of New South Wales. It's a pleasure to welcome you here today, and my role is just to give a brief introduction to the conference and the topic. But let me first start by thanking the European Union, who has provided funding for the conference through the Jean Monnet project, as well as the Italian government and the Ministry of University and Research, who has also provided funding for session 1 of the conference through the PNRR funding. More thanks at the end of the conference. So it is a pleasure to see this room full of people, and I am particularly grateful to students who have decided to attend the event. And here, leading experts speak about jurisdiction and protection of human rights at sea. So why have we chosen this topic? Why should we speak about jurisdiction and protection of human rights at sea? This is a topic that is quite new, is a topic that was not discussed until quite recently. And the reason is that on one hand, there was little awareness of the factual background that has actually promoted the discussions. On the other hand, as we will see, there were some legal technical issues that didn't allow scholars to think outside defined categories. So if we think about protection of human rights at sea, today we do know that there are many breaches of human rights at sea. People in Italy are particularly familiar with the drowning of irregular migrants who try to cross the Mediterranean due to lack of rescue. But we also have other serious situations, such as forced labor and inhuman and degrading treatment in the fisheries sector, not only in faraway places, but also in European waters. We have issues concerning crime committed at sea, crime not only involving international trafficking of drugs, weapons, people, but also more everyday crime committed on board vessels, including increasingly on board cruise vessels. We have situations in which law enforcement becomes excessive, leading to death and unlawful deprivation of personal liberty. We have situations in which the rights to education, to family life, non-discrimination are being breached. So there is undoubtedly a vast range of human rights abuses at sea. And these are quite numerous because there are quite numerous people at sea. As Stephen Hines has counted, we have millions of people at sea, some 35 millions of persons on every moment out at sea. So we have a vast number of people who are affected, and we need to protect their human rights in the same way that we protect, or we need to protect, or we try to protect human rights of those on land. But what does jurisdiction have to do with this? Jurisdiction is a legal concept. It's not an everyday word. And it is a key concept when it comes to protection of human rights generally, and human rights at sea more specifically. So let me start by very briefly trying to sketch, but this is a very preliminary sketch and we will hear a lot today, what is jurisdiction under international law. So jurisdiction is a fundamental concept of international law. It's a word we see in many different treaties, from the Charter of the United Nations to fundamental human rights treaties such as the International Covenant on Civil and Political Rights, the United Nations Convention on the Law of the Sea, and numberless other treaties. And jurisdiction is directly linked with the main international actor, who remains to date the state. But at the same time, jurisdiction is an elusive concept. It's a concept which defies definitions and categorizations. And it is also a multifaceted concept which may assume diverse meanings in different contexts. Just to provide a few examples, jurisdiction may be used to refer to the power of the state to legislate, enforce its legislation, and adjudicate cases in which this legislation is not complied with. So we speak of jurisdiction in a legislative, enforcement, and adjudicative sense. But jurisdiction may also be the factual exercise of power by the state over persons. So if the state arrests a person, this is an exercise of jurisdiction. If the state pushes back migrants, this is an exercise of jurisdiction. If the state detains a vessel in port because there has been forced labor on board, this is an exercise of jurisdiction. And jurisdiction can be both general, as is the case on land. We generally consider that the state that has sovereignty over a certain portion of land exercises the full range of jurisdiction attributed by international law. But it can also be limited and functional, as happens at sea. So there are numberless concepts of jurisdiction. We have jurisdiction in general international law, we have jurisdiction in the law of the sea, we have jurisdiction in human rights, we have jurisdiction in labor law and other fields. And we not only not have always clear-cut definitions for each individual field, but there can also be some differences, sometimes marked, between jurisdiction as understood in different fields. Now, jurisdiction is closely linked to human rights because actually it is the trigger for the application of human rights. Most human rights treaties provide that states which become parties have the duty to protect the human rights of people under their jurisdiction. This is why it is so important to discuss jurisdiction, because only the state that has jurisdiction over an individual has the duty to protect the human rights of that individual. And this is why jurisdiction, both territorial and extraterritorial, has been conceptualized a lot under human rights law in recent years. And we will have a panel dedicated to this just after lunch. However, the problem is that all this conceptualization has been conducted mostly having in mind situations on land. So when we speak about extraterritorial jurisdiction, we think of cases such as the Bankovic case, in which some NATO states bombed buildings in Serbia and killed people. We think of situations such as the Al-Skaini cases, in which the United Kingdom had military occupied parts of Iraq and therefore was exercising jurisdiction there. We think of cases such as the Öcalan case, in which Turkish agents arrested a person who was physically located in Kenya, thus exercising jurisdiction over this person. But the sea is different. Now, this seems an obvious thing. The sea is different from land, but it is different in two separate ways. First of all, it is different from a factual perspective, not only because it is composed of water rather than earth, but also because it is much vaster. Suffice it to mention that the seas cover more than 70% of the planet Earth, whilst the dry land is 30% of the planet. The seas are difficult to cross because you can cross them only by vessels, and vessels can navigate only up to a certain speed. So yes, you can overfly the sea with airplanes, but apart from very limited instances, you cannot land on sea. You have to land on land. It's also a place where it's not possible to have a fixed settlement of humans on a vast scale. Yes, you may have a vessel with some law enforcement agents that goes around at sea, but you don't have police stations. You may have some people on cruise or on board commercial vessels, but you don't have villages and towns and cities. So there is little possibility of actually effectively controlling this vast space. But apart from the factual differences between the sea and the land, we also have some legal differences. And the main difference is that the powers that states exercise on land and at sea are somewhat different. On land, a state exercises full sovereignty over its entire territory, in principle. Of course, we know there are situations of contested territory, situations of occupation, but these are exceptions. So, as a matter of fact, most states exercise their full sovereignty over their entire land territory. At sea, most of the sea, with the exception of the narrow territorial sea, is not subject to the sovereignty of any state. And actually, 60% of the sea is high seas, so an area beyond the national jurisdiction in a territorial sense. Furthermore, at sea, jurisdiction is often functional, which means that the state does not control everything, as it does on land, from health to commerce to family to sport to whatever. At sea, jurisdiction is often limited to specific activities. So, for example, in the exclusive economic zone, the coastal state may have jurisdiction concerning fishing, but not the transportation of goods. And finally, the basic principle at sea is that jurisdiction is exercised by the flag state. So the state that has provided its flag and its nationality to a vessel. And flag state jurisdiction is different from territorial jurisdiction, but also from personal jurisdiction and other forms of jurisdiction. So we see that jurisdiction is crucial for protecting human rights at sea. Jurisdiction is also something that has been conceptualized having land in mind. So we are here today with a selected group of leading experts in the field to discuss jurisdiction at sea and how it relates to human rights protection. In closing these introductory remarks, I would just like to remind everyone here about a few facts. First of all, we should not forget the historical evolution of the concept. As I mentioned today, jurisdiction is mostly territorial, but that was not always so. So, for example, in Europe in the Middle Ages, but also in other parts of the world, I'm thinking of Southeast Asia before colonization, the main linking criterion was personality. So a state would exercise jurisdiction over its nationals wherever they were, rather than on a specific portion of territory. And also we should not forget that the current understandings of jurisdiction have been criticized by critical legal scholars, which have highlighted the imperialist potential of jurisdiction, and in particular of extraterritorial jurisdiction, as well as its links with colonial domination and imperialism. So jurisdiction could be used to leverage differences, and that could be both a positive fact, but also a negative fact, where it paves the way for colonial domination. Another important point relates to the link between jurisdiction and its consequences. Under most international law rules, jurisdiction is a power attributed to the state. And we know that powers can be exercised or not at the choice of the subject who holds them. So a state that has the power to regulate fishing in the exclusive economic zone may choose whether it will do so or not. But under human rights law, the exercise of jurisdiction creates a duty, and this is the duty to protect human rights. So how do we combine this? How do we combine rules which provide power with rules which create duties? And also, what is the relationship between jurisdiction and different types of obligation? Jurisdiction has been often conceptualized having negative obligations in mind, but there are also positive obligations that could be triggered by the exercise of jurisdiction. And finally, I've mentioned the state so far, but we should not forget other actors, such as corporations, criminal networks, individuals, organizations, which are affected by the exercise of jurisdiction by states, but also can shape that exercise through their pressure and their actions. So, to conclude, I think we have a lot to discuss today, and we should never forget that jurisdiction, when it comes to protection of human rights, including human rights at sea, is first and foremost a way to identify a state that has the duty to protect human rights. Because if we don't identify that state, then states will usually shy away from the possibility to protect human rights. So, in the end, identifying jurisdictional links and clarify them is about establishing the rule of law at sea and preventing impunity. I will now conclude here, and I will give the floor to Professor Tullio Treves. Professor Treves is Emeritus Professor at the University of Milan. He has been a judge at the International Tribunal for the Law of the Sea since its inception, and has also been President of the Seabed Dispute Chamber of the Tribunal. He has a long list of publications, including a Hague course, manuals on international law, hundreds of articles and book chapters. He has held leading positions not only in academia, but also in diplomatic contexts. But I think I don't need to go into the details. So we are particularly grateful for Professor Treves for being here with us and providing the keynote to this conference. Thank you.
Good morning, everybody. Thanks to Irini for having convened such an impressive gathering around a subject that is, by the standards of international law, relatively new. We are, and I will be extremely brief because, in fact, the keynote speech was just the one you've heard from Irini a few minutes ago. But I just wanted to underscore that the subject of our symposium today is at the crossroads between two, I would say, solid and consolidated branches of international law. The law of the sea, as old as Grotius, and the law of human rights, perhaps not as old, but now quite has made its proof during the last 100 years. These two areas of the law have been seen for decades as totally separate one from another. The law of the sea deals with interstate relationships. Human rights law, even though it is also a state-to-state subject, but it involves individuals, while the law of the sea, at least at first blush, doesn't do so. What has happened during the last, I would say, couple of decades is that the two subjects have found point of contact. They are not as separate as a dogmatic approach would indicate. Just to make one or two examples, human rights values are to be found and have been found even in provisions of the Law of the Sea Convention. In particular, just to recall a couple, under Article 73, paragraph 3 of the UNCLOS, penalties for violations of fisheries provisions must not include imprisonment or any form of corporal punishment. It means that only monetary penalties can be imposed for these violations. In matters of pollution, under Article 230, again, only monetary penalties are permitted. What does this has to do with human rights? Well, why in a Law of the Sea Convention should there be a provision excluding imprisonment or corporal punishment? Of course, because the legislator of the UNCLOS was keen on preserving persons who may be involved in these cases of enforcement of international law rules of the convention. And at the same time, we see that in the jurisprudence of international courts and tribunals, some human rights keen concepts have been accepted. So the idea of consideration of humanity has emerged since the Corfu Channel decision of the International Court of Justice, the first judgment of the International Court of Justice, and in other decisions such as the Saiga number 2 judgment, the first substantive judgment of the new Law of the Sea Tribunal. And we have also seen that in the jurisprudence of the European Court of Human Rights, the Law of the Sea, of course, a court that deals with human rights, the law of the sea concepts are starting to penetrate. And this was done in the Hirsi case, in the Manguras case, and many other cases. So there is a kind of coming together on specific points of the two separate and discrete areas of the law. In light of all this and of other elements of practice, our convener, Irini, has come to the conclusion that there is a general principle for dictating the protection of people at sea. Of course, she has written 300 pages about it. I have only 2 or 3 minutes, but still this is a very worthy conclusion because it puts together this slow reciprocal approaching of the two subjects. Of course, it is, I would say, still open what would be the legal nature of this, we can call it for provisionally general principle. Is it a customary rule? Is it a general principle of law? Is it a doctrinal simplification of separate items of the practice? This is a very good subject for discussion. One may also think, as I had suggested many years ago, that it could be seen as an interpretive principle to reconcile divergent possible applications of principles of law. Of course, if we are looking into the legal nature of this principle, we must, and I conclude my short remarks here, underscore that the perspective may be different if we consider the matter in general terms and if we consider it from the angle of the jurisdiction of international courts and tribunals. The submission to a court or tribunal of a case depends on the agreement of the parties and on the law applicable to the specific jurisdictional matter. And this may make, let's say, the convergence of sources coming from law of the sea and from human rights more difficult than if we look at it in general terms. But I'm sure that in this room there will be a lot of people that have been thinking about these matters, and we are eager to listen to them in what promises to be a very stimulating symposium. Thank you, Rini. Thank you for your patience.
Thank you very much, Professor Treves. I would like now to invite the chair and the speakers of the first session to take the floor.
I'm very grateful to my former colleague Irini Papanikolaou for having honored me with the task of chairing this session of the conference. And I like it because, first of all, it gives me the opportunity to come back to this university where I was a professor for many years before retirement. And then because it is a very easy task, just to direct the traffic and giving the floor to speaker, no obligation to say something thought-provoking about the subject of this meeting. jurisdiction at sea and the protection of human rights, a very challenging subject. We have the concept of jurisdiction, which is in itself a very elusive concept. It comes from Latin. It means apparently the right to say what is the right, the power to say what is the right. So it is a power of a judge who takes a decision. It is a power of the parliament which adopts legislation. It is a power of the government which enforces the legislation. And personally, I strongly disagree with the judgment of the European Court of Human Rights on the Bankovic case, which was mentioned by Professor Papanikolaou, because in my view, bombing another state is an extreme example of jurisdiction, of enforcing what apparently is the law, and the European Court of Human Rights declined the jurisdiction, declined the application of the European Convention on Human Rights. Anyway, so we are moving from a concept which is not very clear, and especially it is not clear inside maritime environment. While on land we have a territory, we have the full jurisdiction of a given state. On the sea we have different zones. The territorial sea, in this case we have the jurisdiction of the coastal state, but we have some exceptions, innocent passage. Then we have the exclusive economic zone, where some rights are given to the coastal state and other rights are given to other states. And then we have the high seas. So how we could apply this concept of jurisdiction in an environment which is different from land. This being said, I think that I have to give the floor to the first speaker of the session. I feel the responsibility of taking care of the right of the future generations of speakers. So especially to the first speakers, I would recommend the time limit of 20 minutes. And the only instrument for measuring time here is my watch. And so it is with great pleasure that I give the floor to Professor Richard Barnes of the University of Lincoln. Professor Barnes is an authority in the area of interplay between the law of the sea and other fields of law. He is the author of many publications, in particularly of the book Property Rights and Natural Resources, which won the Society of Legal Scholars Prize for outstanding legal scholarship. And the subject of his presentation is justifying jurisdiction at sea. Please, you have the floor.
Yeah, it's plugged in over there, but I can't.
I do it for you, so I sit there and you need to change.
Okay.
Just
Thank you. Sorry, small technical hitch. Okay, whilst we're waiting for the slides here, I should say I'm of a generation here where I didn't learn to speak without slides, so if I don't have slides, I can't remember what I'm going to say. But I'll just make it up as I go along anyway, which seems to be a theme for jurisdiction over the ages. Okay, so I'm a law of the sea person by background, and so my talk will focus very much on how jurisdiction has evolved and has operated in a law of the sea context. And I make no apologies for ignoring the human rights angles of this. The conference has to have a degree of balance, so if I speak about law of the sea, then it will perhaps feed and prime some of the discussions about how law of the sea shapes jurisdiction vis-à-vis human rights. Just to put things into context a little bit, picking up on a theme which Professor Treves noted, the issue of human rights at sea brings us to a crossroads. In one direction we have law of the sea, in the other direction we have human rights. And it raises a question about perhaps which direction we should follow when we reach this crossroads. Should we look for a solution based in law of the sea or human rights, or do we need to forge a new pathway? And I guess taking that as the starting point, and given what Irini said about the different nature of jurisdiction, it begs some questions about how do we decide which jurisdictional approach to take, and is there any way in which we can think about how jurisdiction is justified, which gives us a sense of what priorities or what considerations we should take into account when thinking about jurisdiction. So for me, I think this is quite important, because if we think about what justifies jurisdiction, what reasons have been given for jurisdiction, what fundamental principles, moral, political, or other, have been given for jurisdiction, if we go back to these first principles, then does it allow us to think about how to resolve some of these potential conflicts or some of these potential choices that we're faced with when we try and resolve some of the jurisdictional issues that we face? So that's my approach here, to think about going back to first principles and what justifies jurisdiction. So I'll begin my talk with some observations on how jurisdiction operates, and I'll keep this quite brief given what Irini has already said. In the second part of my talk, I want to focus on jurisdiction and substance. I think this is important. Often jurisdiction is seen, at least from a human rights perspective, as being a trigger for what other substantive rights operate. But if we look at the law of the sea, well, actually, jurisdiction is intimately bound up with those substantive rights. The whole point of jurisdiction at sea is to enable certain types of right and sometimes responsibility to be given effect to. So when we think about jurisdiction under the law of the sea, it's sometimes quite difficult to separate this out from the consequences of jurisdiction. I then want to give some examples of how maritime jurisdiction has evolved. And in particular, what I want to try and do is to draw out some of the reasons which have been given for this, the rationales or the justifications. And to kind of cut to the point, when we think about the law of the sea, it's primarily concerned with the regulation of things or resources. It's very territorial or very property-esque in its approach. And so jurisdiction is often framed as a series of claim rights or entitlements. And so fundamentally, this limits the ways in which jurisdiction is shaped. So if we kind of unpack that, then can we identify any of the reasons, fundamental reasons, from the development of the law of the sea, which can help us think more differently about that? Okay, so just by way of kind of basic introduction here, Mann is often cited as being one of the leading authorities on jurisdiction. And he describes international jurisdiction as being an aspect or ingredient or consequence of sovereignty. And I think this is quite an important point here, because when we think about jurisdiction, one of the kind of fundamental justifications that are given for this is the idea that somehow jurisdiction is essential to the functioning of the state. If states don't have an authority to do something, then it limits what they are. So in a sense, it's a structural consequence of the existence of states. And also flowing from this is the idea then that jurisdiction, in a sense, is perhaps a product of international law. International law being law by states, for states, it emanates from the voluntary will of states. And so in a sense, jurisdiction is somehow predicated on that idea of voluntary intercourse between states. But in some ways, I think this is a little bit limited, because it doesn't really tell us why or what the rationale for that jurisdiction is. It simply locates it in a sense of authority or power, but it doesn't tell us anything about why that power exists or should exist. If we look at jurisdiction, there seem to be three main ways in which jurisdiction has been conceived of in law. And again, these are very broad brush approaches. They're not entirely discrete, they're not entirely chronological, but they give us a sense of how we can view it. So the first one is what we might call the permissive approach to jurisdiction. This is captured by the Lotus case. And the rationale here is in a sense that states, unless they are specifically prohibited or limited from doing something, have a plenary authority to act. So in the case of the Lotus, there weren't any particular restrictions on the arrest and prosecution of a person on board a vessel involved in a collision, and so a state was entitled to exercise jurisdiction in the absence of prohibitions. This has been much criticized, this case, for a number of reasons. And I'll not go into those. The second view of jurisdiction is what you might call the traditional view. And whereas under the Lotus case, jurisdiction, or in a sense, authority is a kind of pre-existing fact, it exists before international law, and international law restricts that. Under the traditional view, sovereignty is defined by international law, and so jurisdiction is defined by international law, and so international law provides a fundamental shaping and constraining influence on the exercise of jurisdiction. In both of these views, however, what we look at here is, in a sense, something which is a claim, a power, an authority. It's very much viewed in a sense of an entitlement to act or a way of acting, and it's also viewed as being discretionary. And this is quite important because it doesn't imbue sovereignty with what you might call a sense of responsibility. There is no duty to act in a particular way. It is merely a power to act. And there's contrast with what you might call the modern view of jurisdiction. And this is very much more associated with the emergence of human rights here. The idea that states themselves have certain responsibilities towards individuals, and that in certain circumstances where they exercise jurisdiction, they have to act and uphold human rights. And this fundamentally challenges things. So we've got these three different views of jurisdiction which have evolved over time. So having sort of given that sort of overview of the way in which jurisdiction might be conceived, I just want to briefly say something about jurisdiction in the law of the sea. And this in some ways is very, very simple. Jurisdiction in the law of the sea, as Irene has mentioned, is functional. So in a sense, jurisdiction evolved to give states authority to govern certain types of activity at sea, whether it's fishing, navigation, so on and so forth. And it does this in a particular way. And as a kind of general rule here, within the territorial sea, states have plenary authority to exercise control over things as long as they don't interfere with innocent passage. Within the continental shelf and the EEZ, states exercise jurisdiction over natural resources. It's an entitlement to exercise exploitation rights over those resources. And then on the high seas, there is no spatial jurisdiction, there is exclusive flag state jurisdiction. So these are the kind of simple bases of jurisdiction. But the point to stress here is that they are very much focused upon enabling states to exercise functional control over particular activities. They're not so much concerned with the exercise of responsibilities. So, coming on to the next part of my talk, if we look at the law of the sea, we can also classify jurisdiction in terms of the substantive provisions of the Law of the Sea Convention in different ways here. So the first of these is the idea of resource jurisdiction. If we look at the development of the law of the sea, jurisdiction evolved in order to give states the ability to control certain natural resources, whether it's fisheries, mineral and gas on the continental shelf, and even the protection of the environment. And so if we think about it as resource jurisdiction, we're thinking about how states exercise control over things, and it's an interstate set of agreements between states about the allocation or the distribution of valuable natural resources. And so when we think about how jurisdiction is justified, we're looking for a series of principles which justify or explain the division of natural resources. I'll come back to that in a moment. The second area of kind of jurisdiction and substance is to do with what you might call transactional or communication jurisdiction. It's possible to divide the law, the oceans up into what you might call natural lakes and to give each state full plenary competence over these. But it ignores the fact that in most areas of international law of the sea, we still need states to permeate, we still need states to transact with each other, and they need to communicate with each other. So there still have to be some principles which allow states to engage in activities which cross or transcend borders. These are rights of communication, the rights to lay submarine pipelines and cables. You might even include with this freedom of navigation and navigational rights. They are fundamental to maintaining the communications between states. And so the principles behind that are very much transactional. They enable communications. And the last set of kind of areas of jurisdiction in the law of the sea are what we might call police or security ones, but they're very much more marginal. If we look at the law of the sea, there are very few provisions which deal specifically with policing or security matters. This is somewhat of a gap area, an area which has been brought into relief with the questions about human rights here. I'll come back to this in a moment, because one of the things I wanted to flag up here is that whilst there are kind of provisions for the exercise of jurisdiction over policing and security matters in respect of piracy or criminal activities at sea, they're very much becoming influenced by what we might call the securitization doctrine. Increasingly, states are exercising a prophylactic role to prevent things from happening, to stop certain things coming into their territories. And so this form of jurisdiction is being driven in directions which may contradict the way in which human rights operate. Okay, so quickly just to run through some of the ways in which maritime jurisdiction is exercised. I probably don't have time to go into all of these in huge detail, but one of the points that I want to stress here is that whilst we have these jurisdictional principles in the law of the sea, they have evolved over time, and jurisdiction has not remained static. It's gradually grown, acquiesced, it's changed, it's evolved, and so jurisdiction is very much a dynamic process. So that's the first thing to know. The second thing to note is that in terms of the justifications that have been provided for jurisdiction, they're often attached to particular types of activity, and from these activities we can derive out some sort of principles. So if you look at, for example, the territorial sea, the EZ, the two main drivers behind the extension of jurisdiction here are to secure control over fisheries or to protect the state from threats. So we have the cannon shot rule, which allows states to exercise control over waters as far as the cannon shot goes. There are other justifications. There's a good one in Scots law, which was called land kenning, the idea that you could exercise jurisdiction out to sea as far as you could see. And I think that's a wonderful idea, the idea that if you see something, you control it. So maybe not a good way of justifying jurisdiction, but certainly one that fed into the justification for the territorial sea. So these are things, and the point to stress here is that why jurisdiction exists is because states wanted security or because they wanted natural resources. The second thing to note about jurisdiction is that it wasn't a product really initially of international law. If we look at some leading cases, what we see is a recognition that actually authority over the sea, the extent of jurisdiction, followed from the sovereignty of the state itself. So the state had to claim and justify jurisdiction. Recognised in the case of R against Keane, the UK wished to prosecute a master on board a vessel for offences caused in its territorial sea. But because the UK hadn't exercised and claimed jurisdiction over that area, it was unable to exercise that form of jurisdiction. So until the state itself extended jurisdiction, it didn't exist. So in a sense, it's again reaffirming this idea of jurisdiction being a claim, an entitlement flowing from the state itself. I don't have time to go into the doctrinal justifications for this, but one of the things I wanted to flag here was that even in terms of these claims, there were some limitations. The idea that the justification for control of the fisheries or for security was rooted in a part in the agency of the state here. So if the state was to function, if the state was required to do particular activities, it had to have an authority which allowed it to do those things. So in a sense, it was very much bound up with the agency of the state or its liberty to do certain things. If we look at the continental shelf, again, this is a zone, the seabed, which extends underneath the super-adjacent waters from the land of the state. And over it, states have, at the current time, exclusive rights for the purposes of exploring and exploiting the continental shelf, i.e. drilling for offshore oil and gas. Now, until the 20th century, this regime did not exist. And so states had to put forward a basis for justifying the extension of jurisdiction or control over this. And this can be traced back to the Truman Proclamation of 1945, where the US asserted that it would be reasonable and just, since effectiveness of measures to utilize or conserve resources should be contingent upon cooperation and protection from the shore. So because of the proximity of the shelf, because of the need to provide some degree of control over it, a state was justified in extending its control over the continental shelf. Subsequently, the regime was recognized in the continental shelf case of 1969. The International Court of Justice recognized these rights as being, they exist ipso facto and ab initio. So in a sense, they are inherent in the state itself. But again, to stress, jurisdiction evolved to give states control over resources. Again, with the exclusive economic zone, a zone out to 200 nautical miles, we can see a similar process justifying the extension of jurisdiction. So when states were looking to justify the creation de novo of a new zone of control, they put forward certain rationales for this. And a couple of examples here. The Mexico City Principles, which were put together by Latin American states, said that coastal states have an exclusive right to exploit species closely related to the coast, and in particular because this was something which the coastal population depended upon. So jurisdiction justified according to some form of need or ability to satisfy the agency needs of the state. Again, in the International Court of Justice case of the fisheries jurisdiction, whilst Iceland's claims to an extensive exclusive fishery zone were rejected, the International Court of Justice recognized that in some circumstances, jurisdiction may be justified to recognize the preferential rights of the coastal state. So again, a needs-based approach here. Thanks. I mentioned previously, please. Okay, it's good. Just making sure that it wasn't going on too long, so it's been known to happen. So coming back to police and security jurisdiction, so as I've emphasized, the law of the sea is primarily concerned with the governance of natural resources, and what it's done through a series of kind of claim rights is consolidated its coastal state control over those resources because they seem to be either closely associated with that state or they're somehow needed for the state's exercise of authority or to maintain its political liberty. This is slightly different for the police and security jurisdiction because we've only got a few provisions which deal with this in the Law of the Sea Convention. And so it's not so much concerned with this, at least explicitly. It may be implicit in the idea of jurisdiction, but there are very few express provisions which deal with this. So for example, in the territorial sea, we've got Article 28, which shows that coastal states can exercise criminal jurisdiction in the territorial sea, but they shouldn't unduly interfere with the vessels which are exercising innocent passage. So it recognizes that jurisdiction. Article 97, again, in terms of the kind of provisions on the high seas, we've got a variety of different provisions where coastal states are allowed to exercise jurisdiction over vessels engaged in substantial wrongdoing, piracy, slavery, unauthorized broadcasting, and so on. But other than these kind of provisions which deal specifically with criminal conduct, there are very few express provisions dealing with what you might call police or security jurisdiction. And so for the most part, this is evolved by ad hoc agreements where states voluntarily enter into agreements where they allow each other to exercise jurisdiction in particular circumstances. So we've got a number of conventions on the suppression of drug trafficking, unlawful activities at sea, where we have ad hoc jurisdictional arrangements. So in principle, the law of the sea isn't immune to the idea of having ad hoc agreements and to adapting jurisdictional frameworks, but these always start from the kind of basic principles of spatial jurisdiction within maritime zones or exclusive flag state jurisdiction, and they operate as a series of exceptions to that. Okay, so coming then to the kind of final parts of my talk, just to think about justifying jurisdiction. So what I've tried to do is to kind of stress the fact that within the law of the sea, it's very much focused on the distribution of natural resources. And so this kind of gives rise to a certain series of kind of principles or concerns which have dominated the justification or the distribution of jurisdiction. So the first of these, I guess, is one of public order. So the idea here being that it's a function of law to distribute authority. And so there has to be some form of authority distributed, otherwise law does not work. Seems to be fairly axiomatic, seems to be fairly simple. And if we look at the Law of the Sea Convention, it talks about establishing a system of public order for the world's oceans. And I think that's kind of useful. And what we have is a kind of clear set of rules within the Law of the Sea Convention which distribute authority. But what we don't have behind that, though, is really a clear sense of normative order for the oceans. It doesn't tell us whether or not it is good or bad. We don't have any kind of benchmarks for that kind of public order. So if we're going to see jurisdiction as being justified according to its maintenance of order, it demands that we think a little bit more deeply and carefully about what good order might actually look like. And if it comes down to the kind of disputes that we're seeing, for example, a conflict between two states as to whether or not they should engage in search and rescue operations, are there any kind of normative principles behind that which we need to look to in order to try and allocate or decide who ought to have jurisdiction? And I guess the point I'm going to make is that we're probably not going to find those order principles within the law of the sea itself. The second sort of set of principles behind the allocation of jurisdiction at sea is to do with agency. So the idea here is that most of the claims which have been extended into maritime spaces have been done on the basis that they are necessary in order for the state to give effect to its kind of functions as a kind of political entity. Unless states have resources, then they are unable to supply the needs of food supply for the sustenance of their populations. It's, again, fairly axiomatic, but it doesn't tell us enough about how and why those resources should be used. The third justification which is linked to this is one of liberty. And I guess if we think about, for example, the justifications of property, the idea behind this is unless you give a political entity a certain degree of material agency, then it will be unable to give effect to its kind of political liberty because it becomes dependent upon other states for the means of its political liberty. So the idea here that unless states have access to adequate resources, it will undermine their material liberty. So there's possibly here what you might call a political liberty-based justification for the exercise of jurisdiction at sea. And then finally, we've got a kind of legitimacy function for jurisdiction. This is slightly different. The idea behind this is that when we allocate jurisdiction, in a sense, it gives a form of legitimacy or a form of authority to the person who holds that. In a sense, it recognizes that they are a proper person to exercise authority. So, for example, within the EEZ, and we think about the management of fisheries, there is the idea that the coastal state is not just exercising control because it can or it wants to exploit those, but because it's in a position to exercise responsible management of those resources. So sometimes the idea is that jurisdiction signals who ought to speak for a particular matter. So we've got a number of different justifications which can perhaps be derived from some of the development of the law of the sea. Last point. So I guess coming back to the kind of key point here is that can we dig behind the law and think a little bit more deeply about why we give authority to particular actors? And are there any fundamental principles which we can look to which can help us synthesize the way in which jurisdiction operates? Because if we look at the simple exercise of the rules, then they don't always resolve these conflicts. We need to go behind them and think about how we can ascertain what you might call common language or concepts in order to translate the way in which jurisdiction operates. So, final points here. Jurisdiction under the law of the sea is not static. It's evolved and it will continue to evolve over time, and it does so in response to a number of pressures. And interestingly, we're faced with very important drivers for the protection of human rights, and it will be interesting to see how it responds to that. The second thing to note is that there are a number of different justifications for authority which have evolved over time, and I think we have to have a pluralistic justification for how jurisdiction operates. It's mainly been resource-driven and claim right-driven, and what that has tended to do is to imbue the law of the sea with a sense of entitlement rather than responsibility. And it's this idea of responsible jurisdiction that we lack in the law of the sea, and we perhaps need to seek from somewhere else. Whilst I'm very, I wouldn't say negative or cautious about what the law of the sea does, there is some glimmer of light in terms of how it's developing. So I've got a quote here from the recent BBNJ agreement. And in the preamble to this agreement, one of the things it talks about is the idea of states acting as stewards for the ocean. And so this is the first time we're seeing sort of things being framed in the law of the sea as a set of responsibilities in and of themselves, rather than as being kind of restrictions on the exercise of claim rights. And if states are exercising that kind of stewardship responsibility, what it kind of points to, I think, here is the idea that if you claim certain rights and entitlements and benefits, then you also have to think about the responsibilities that entails. The history of the law of the sea has been very much a pick and mix approach, where states have selected the things which they want and like and benefit them, but they haven't always taken the responsibilities that go with that. What we're seeing increasingly now is a recognition that they have to assume those responsibilities. And if that's the case, then when it comes to things like fisheries management, exploitation resources, management of navigation, it's not just simply the freedom to control those, but it's a responsibility to exercise that in particular ways. And I'll finish there.
I thank Professor Barnes for having clarified the concept of jurisdiction, both on its general terms and as regards its application in the law of the sea. That's a dynamic concept. It changes with the evolution of times, and it's a question of allocation and distribution of responsibilities. I would say that's the only case in the law of the sea that we have universal jurisdiction. Every state is entitled to exercise jurisdiction is piracy for a traditional rules. And even in this case, what is strange is that the problem was not so much that more than two states wanted to exercise jurisdiction over pirates, but it was the contrary, that it happened that a state which had arrested a pirate on the high seas didn't want to exercise its jurisdiction, for not being burdened by the fact of organizing a trial at home, and released the pirate without trial. So when we had universal jurisdiction, nobody wanted to exercise the jurisdiction. In any case, now we are moving to another subject. We have Professor Sarah Seck of the Dalhousie University in Canada. She is director of the Marine and Environmental Law Institute at that university. She is engaged in many research endeavors, both individual and collective, notably also the publication of the Ocean Yearbook, which since many years is a well-known publication in the field of law of the sea. And recently she has conducted research on behalf of the United Nations Environment Programme on questions relating to business, human rights, and environment, including human rights responsible business within the question of climate change. And that's the subject of her intervention, jurisdiction over corporate actors in international law. We have this new concept of social corporate responsibility, which is a very interesting one, a sort of responsibility and obligations falling over transnational corporation, and this is applicable also within law of the sea. So, please, you have the floor, Professor Beck.
No. There, yes? Okay, wonderful. Thank you very much for the kind introduction and also very much for the invitation to participate in this workshop. I'm very excited to be here and to listen and learn from the other speakers. I'm going to attempt to cover 3 basic questions in my talk today. First, I'm going to introduce something that has been a preoccupation of mine for the last few years, which is to develop what I'm calling a relational approach to international legal analysis. Secondly, I'm going to explore here how a relational approach in my work has been used to clarify the international law of jurisdiction over corporate actors, and this includes both the nature of state obligations and also moving into this realm of corporate social responsibility, how we understand transnational business responsibilities. And then third, to reflect on how relevant this approach might be to jurisdiction over corporate actors under law of the sea, and so therefore the protection of people and human rights at sea. And I'll note that this third part, of course, is very much under development. This hasn't been a focus of my work. I anticipate it will be a focus of my work moving forward in the next few years. So we'll see where we are at this point. I want to start first just with a reflection on why it is that I have gradually moved to thinking about a relational approach. And when I started and was working on my PhD research in Canada, the focus of my work was, the title of my PhD is Home State Obligations for the Prevention and Remediation of Transnational Harms, Canada, Global Mining, and Local Community. And I'll note that, first of all, in this research, and in much of my work, I very much see human rights and environmental issues as intertwined. This comes in part from looking at the challenges in global mining, where you often have local communities, often indigenous communities, who are very concerned about environmental impacts, and yet the way in which they can seek to challenge the conduct is through human rights, whether it's indigenous rights and the UN Declaration of the Rights of Indigenous Peoples, or procedural aspects of environmental human rights. And so for me, these two are very, very intertwined. At the time I was embarking on my research, the Standing Committee of Foreign Affairs and International Trade of the Canadian government came out with a report that said Canada must do something about regulating Canadian-based mining companies that are operating internationally to prevent and remedy human rights and environmental issues. It has an obligation. The government response didn't take issue with the obligation. It quite simply said, well, that's lovely. We would love to, but we can't, because this would be an extraterritorial exercise of jurisdiction that would violate the sovereignty of host states. And so it seems to me there's something very interesting going on. There was something very interesting going on. On the one hand, you have human rights advocates arguing for an obligation, and on the other hand, you have states saying, not only do we not have an obligation, but we're not allowed. And so I think this sort of curiosity has informed my approach to jurisdiction generally. And I note also that at the time of starting out, I came across this interesting text from Andreas Lowenfeld in the private international law field, noting that when you read a book or a title or attend a symposium with extraterritorial jurisdiction in the title, be advised that the authors or editors or sponsors are attempting to communicate an attitude before the audience has read or heard a single phrase. And so in this, while I think the concept of extraterritoriality can be very useful as an analytical tool, it's been, at least in my work, very difficult to not see it as having a normative and sort of political dimension. And therefore to explore, as I have, how can one consider the role of states and their exercise of jurisdiction in ways that transcends borders without bringing with it the baggage that comes from taking a territorial focus and using the language of extraterritorial. So I think thinking of things in an extraterritorial way necessarily requires us to think about, is there sovereignty infringement going on, and if so, what do we make of that? Now, the second reason that I would give for exploring a relational approach is very much tied to being a Canadian. I am located in what we would normally call Nova Scotia in Canada, but I have here what's known as a land acknowledgement, and this is the land acknowledgement of our university. The Dalhousie University is located in Mi'kma'ki, the ancestral and unceded territory of the Mi'kmaq. We are all treaty people. Now, as an international lawyer, the land acknowledgement of my university puts in my face every day the fact that there's a problem with international law, which is that the underlying peace and friendship treaties that govern the land on which I live are not part of the UN treaty database. And so the idea that international law has had a civilizing mission that erases indigenous jurisdiction is something that I am obliged to sort of confront in my work, and I think that also informs thinking about jurisdiction. So what is a relational approach and why is it necessary? My claim is that what I describe as the bounded autonomous individual of liberal thought plays a dominant but also unacknowledged role in everyday thinking and legal analysis, and this includes in the international law context. It's a problem because it isn't true. Individuals do not become autonomous unless they're surrounded by relationships that nurture them and support their autonomy. And this is equally true of states, and I'll say more about that in a minute. And my claim also would be that this sort of hidden bounded autonomous individual inhibits global problem solving and our thinking. What I'm currently proposing is to replace the bounded autonomous individual, and this I will note is a work in progress, with what I'm increasingly calling the differentially situated, ecologically embedded relational individual. I'll unpack that. First of all, individuals are obviously in and part of social relationships, and I've said relational and nurturing relationships are what support autonomy. But also, humans are also embedded in ecological systems, and so our health and autonomy is non-existent if we do not understand and support and reciprocally engage in our responsibility towards the ecological systems in which we're embedded, whether local, transnational, or global. And the differentially situated is in there to capture the fact that we do not all come to the table in the same capacity. Of course, again, in the Canadian context, we're conscious of the colonial histories and the residential school system and problems, challenges that have arisen for Indigenous communities. But more broadly, this is to account for, of course, many other kinds of differences that we need to be aware of. Now, what does this mean for international law? Here I draw in part quite extensively on work that Karen Knopp conducted, in particular in 1993 paper called Feminist Restatements. And I've explored this in other ways as well. My claim, again, is that this bounded autonomous individual has sort of infiltrated international law in the construct of the sovereign state. What it does, if we think about it, going back to the individual that pretends that it doesn't need anybody, we think of the state in the same way, that states can put up and erect boundaries, do whatever they want within those boundaries, and be living well and happily without caring about what happens in the rest of the world. And of course, this is simply not true. It's not true from an ecological perspective, and climate change would be but not the only example of that. But it's also not true given the transnational networks from an economic perspective, which are very much a part of how states operate today. But drawing on Karen's work there and on others, there are a number of different sort of ways of reimagining international law that come through. Of course, from the perspective of jurisdiction, I have in bold and sort of underlined the need to challenge or at least be critical of the assumption of the territorially bounded state, which I suggest, again, silences the realities of interdependence, whether it's transnational, economic, or ecological. And I suggest that when we think of jurisdiction, we should really be focusing on what is the relationship at issue, that should be our primary question. But I note some other aspects. First, a presumption, again, that the state is the primary actor. And I go back to the UN Declaration on the Rights of Indigenous Peoples. We could say that, and we as international lawyers would generally tend to say, well, it's a UN General Assembly resolution, therefore it has a certain status in international law. But it isn't like states woke up one morning and said, hey, let's recognize the rights of Indigenous people. Wouldn't that be great? No, Indigenous peoples worked together collectively across the globe for decades, not to fight for their rights in that sense, but to force states to recognize the existence of their rights. So the UN Declaration recognizes their rights, and the rights sort of pre-existed the recognition by states. So I think it's important when we look at normative instruments, human rights instruments, that we don't take the rights holders out of the equation when it comes to sort of assessing the normative value. And I think the UN Declaration on the Rights of Indigenous Peoples is a key instrument for that. Why shouldn't how Indigenous peoples understand its normative weight be relevant to international legal analysis? And what happens when we cut them out? A second point, which again relates to this, is the idea of the unified state. International law just assumes that everybody in the state is kind of one and the same. I could say in the climate context, for example, Canada as a rich, developed state has responsibilities that it tends to renege on, but we also, in the Canadian context, the Inuit, for example, are particularly vulnerable to climate harms, and they are making claims in the international arena that this should entitle them to be able to access funds through the Loss and Damage Fund. I'm not suggesting that that necessarily is what should happen, but I think the point here again is that the assumption of a unified state is an assumption that international law makes, and it is not necessarily reflective of the realities. Again, in the Indigenous context, there are overlapping and interdependent sovereignties that need to be accounted for. Another point is assumptions about states being equal, and of course, for those who engage in literature of drawing on third world approaches to international law, for example, but even thinking about common but differentiated responsibilities in international environmental law. We're very clear that while sovereign equality is obviously a fundamental principle of international law, we shouldn't ignore the reality that states are not equal in different ways, and therefore power of states and how we account for that is important. And then finally, jumping to the bottom, some cautions on bright line boundaries and assumptions that are made even with regard to how we think about public versus private actors. So it's common to say, well, corporations have these obligations or responsibilities, states have these other obligations. But the line between public and private is much less bright than one might think. First of all, there are many state-owned enterprises. Some state-owned enterprises may even be partially publicly owned and listed on the New York Stock Exchange, for example. I'm thinking of some large carbon major companies, for example. So it's not so simple always to say that this is the state versus this is a private actor. And this comes up in many different ways. We could even, in some early work looking at the Articles of State Responsibility, I paid some time thinking about Article 4, which is about organs of the state, and you could look at corporate actors merely as creatures of legislative state organ acts that create the possibility for incorporation and so on. So again, caution in that context, I think, is part of the process of reimagining international law in a relational way. What are the implications? I mean, there are a lot of different implications. I think for myself, the focus being a quest for what I would call local and global socio-ecological justice, I think it's important to pay attention to and confront the bounded autonomous individual wherever one might see it, but at the same time to be cautious about universality of any message, to reflect on who is the we that is sort of at the table saying we need to do this, we need to do that, what might this look like? So the key questions that I ask in my research when adopting this relational approach is to ask, what patterns of relationships do we wish to nurture between people and the material world? And secondly, what relationships do we have a responsibility to nurture? Here, drawing in part again on the work of some Indigenous colleagues of mine in the Canadian context, we see Indigenous laws talking about reciprocal responsibilities and relationships between people and the natural world, future generations. This is just a part of many Indigenous worldviews. And to the extent that we reflect back on Dalhousie's land acknowledgement, one part of it is to note that we are all treaty people. So it isn't simply a question of the Indigenous communities in Mi'kma'ki holding certain views, but because I live in Mi'kma'ki, I am part of that treaty relationship, and therefore I need to learn and respect and understand views coming from local Indigenous laws, including Indigenous ecological ways of thinking. Okay, so I probably used up a lot of time already. Whoa, okay. So I'm going to quickly then go from that to some of the sort of key thinking. In the business and human rights context, I obviously have engaged a lot with the 2011 UN Guiding Principles on Business and Human Rights, which talk about state duties and also business responsibilities. Within the state duties, we talk a lot about the responsibilities of host states, but also of home states. We talk about the importance of understanding the independent responsibilities of businesses, because we assume that states will often not fulfill their obligations and responsibilities, and therefore businesses should not use the failure of states as an excuse for not stepping up and taking on their own responsibilities. Business responsibilities extend to supply and value chain relationships, and in particular, as I think through an environmental lens, the recognition by the UN of the right to a clean, healthy, and sustainable environment just sort of confirms that the environmental dimensions of human rights are part of the human rights conversation. The next few slides sort of talk in detail about what this might mean in the different contexts. We have host states that have a duty to protect. Some lack capacity, some lack a will. But the state duty also attaches to the home states. Home states can be understood in many different ways. I think of this as a transnational relationship, and there are questions that might flow from this. So does the host state, for example, claim that the host state regulation violates its sovereignty? Does the host state see it as extraterritorial? Does the home state express reluctance to regulate or adjudicate because it sees it as extraterritorial? What might we draw from that? What is the applicable law? Are there enforcement jurisdiction issues? What are the underlying legal structures of control? And then ultimately, what do the rights holders within the host state want? Do they want this regulation or adjudication? Do they want to have input into the design of the regulation and the nature of the claims? These are all questions that one can ask that sort of attempt to sort of get into the weeds of the relationships at issue. The business responsibility to respect, as I've noted, applies to supply and value chain relationships and calls upon businesses to have a human rights policy, to engage in human rights due diligence, and to support remedy. And we can ask similar kinds of questions as we look at the role of business enterprises. And of course, states can require businesses to conduct human rights due diligence, or we see in instruments like the OECD guidelines for multinational enterprises and responsible business conduct an expectation that businesses will be doing this anyway. Here are thoughts on the sort of global ecological context. And because I'm short on time, I'm going to just slip through into some brief thoughts on the law of the sea context. So first, do I think the relational approach might be relevant to these questions? I think absolutely yes. I say this for a number of reasons, but one is Elizabeth Munn Borghese, who's often referred to as the mother of the oceans, has a lot of people have been writing about the relationality that is evident in her non-law of the sea work and how it may have infiltrated and infiltrates her thinking on law of the sea, and I think there's a lot to be said about that. But more generally, I think it's important and also gives us an opportunity to rethink the human who is the holder of rights in the human rights at sea context. I note that we see a sharp division between land and sea, partly because there is this separate body of law called law of the sea. But the fact that there is this separate body of law called law of the sea also reflects a worldview that sees the sea as different from the land, and that isn't necessarily a worldview that is universally shared. If we're thinking about relationships and corporate actors, how might we think about this? Jurisdictionally, this is not even a complete list, but of course there is the flag state, the port state, the coastal state, a sponsoring state if you're looking for particularly at deep seabed mining, a supplying state if you're looking at the state that supplies labor in certain contexts, drawing on what I just shared, a home state, a host state, which could be relevant to many of these different areas. I note Indigenous governance, certainly as we are looking and embarking on a project co-led by the Inuit Circumpolar Council, Indigenous governance in the Arctic shipping context is not something to leave out. In fact, it's an important piece to put in there. And then when we think of actors in the oceans, we think of the ship, but there's the ship owner, the beneficial owner, a contractor, our state-owned enterprises engaged. How do we think of owners, operators? These are just many, this is just a sort of quick, brief mapping of possible relationships that could inform an approach. And then finally, important to note that how we think about what's going on also depends on what kind of actions are involved. There's a lot of data gathering that goes on, and certainly in the business and human rights context, the idea of doing human rights due diligence is very much a data gathering exercise. It's one thing for a state or a business to gather data. It's another thing to ask who that data gets shared with, and then what flows from the gathering of the data in terms of responsibilities. And so I think that's an important question. I think it could also be helpful to think of when are there obligations to prevent harm, and how might we think about that versus remedy. And this, of course, leads to the different types of action and prescriptive, adjudicative, enforcement, connections, and so on. As I know I'm out of time, I'm going to wind up. That's correct, yes. And I'm happy to have further, I look forward to our further conversation and discussions. Thank you.
Thank you very much. Professor Beck has presented a broad vision of the concept of jurisdiction, especially when it applies at sea, and has also stressed the dynamic and evolutionary nature of legal concepts, including jurisdiction. One of her main points was that a state has a duty to protect human rights from business harm, and immediately after we ask the question, what happens if we are on the high seas? Which state has such a duty? The flag state of the ship, the state of nationality of people whose human rights are affected, or the state of the port where the ship is directed. So immediately after, we have many doubts about this obligation. So now we have the third intervention by Professor Cedric Ringert. He is Professor of Public International Law at the University of Utrecht in the Netherlands. He is the author of a book on jurisdiction in international law, so he is the right person in the right place here. And he is also the chair of the Dutch Advisory Council on International Law, which advises the Dutch Foreign Ministry about questions of international law. That you have many problems today with giving advice on international law. But the subject of his intervention is to what extent does the general law of jurisdiction inform human rights jurisdiction at sea. Please, you have the floor.
I speak, yeah, right. Yeah. Thank you so much, Professor Scovazzi, for this very kind introduction and for chairing this wonderful panel. It's my pleasure to share the floor with two great panelists, and I would like to thank the organizers for choosing such a suitable theme, jurisdiction, the law of jurisdiction, jurisdiction being a key issue, a threshold issue. I'm looking at you, Irini, because you explained it so well in your introduction, or should I say your keynote. If the state does not have jurisdiction, the state does not owe human rights obligations to individuals. It cannot guarantee human rights to people at sea. So we need to talk about jurisdiction, right? Whether I'm the right person to do that today, I leave that in the middle. But many of you know that I've published indeed on jurisdiction. I'm supposed to be a specialist in law of, I would say, mainly prescriptive jurisdiction in international law, enforcement jurisdiction as well. But I'm not a human rights person. I'm not a law of the sea person as such. And probably that was the reason why I was invited to come with a somewhat different perspective and to clarify matters. So what can we learn perhaps from general international law and also the law of the sea for this key issue of human rights jurisdiction, and also including, I would say, the second aspect, the human rights obligations, extraterritorial human rights obligations, where jurisdiction also plays this role. There's a dual role of jurisdiction today, so I will draw the bridge a bit with what is going to be said this afternoon as well. I'm the last speaker. I think I can allow myself that liberty. My aim, the aim of my presentation today is not as such to give an overview of what states can do in this or that zone, prescriptive or enforcement jurisdiction. There might be a difference. I think, Richard, you did a good job doing that to a certain extent today. Natalie Klein, who's sitting there, has a great article in Ocean Development and International Law. I really enjoyed that article, giving really a very good overview of what states can do in relation to human rights specifically, and I will focus in my presentation on human rights. And there is the famous Geneva Declaration on Human Rights at Sea, to which I would like to draw your attention. Just do a quick Google search if you're not aware of it yet. Next slide, please. Now, to kick off my presentation, I would just like to add some thoughts on enforcement jurisdiction on the high seas in relation to human rights violations, and to just give you one example, human trafficking, for instance, also in the migration domain, is something that we will talk a bit more often. I guess also in the afternoon, where many other presentations will also, I guess, zoom in on issues of irregular migration at sea, where you have major issues of jurisdiction, human rights jurisdiction under the ECHR, for instance. Now, as you know, and this has already been emphasized, only the flag state has enforcement jurisdiction over vessels on the high seas. But, and here it becomes a bit interesting, we can also discuss that later, in the MV North Star case, International Tribunal for the Law of the Sea, and we have Judge Lisbeth Leinzart here, ruled, Judge Leinzart was in the minority in that case, I have to add that, ruled that the flag state also has exclusive prescriptive jurisdiction. I have to speak a bit closer to the mic, I guess, yeah. Which means that other states would have no jurisdiction. So MV North Star, in case you don't know, that case was about the question whether Italy can exercise its legislative or prescriptive jurisdiction over a vessel engaged in bunkering, which is some kind of refueling on the high seas with yachts, and there was a violation of Italian tax law, custom law, a scheme starting in Italy, enforced in a Spanish port, not at sea. But the thing is, ITLOS ruled here that the flag state has exclusive prescriptive jurisdiction, and that has been more or less been repeated by an arbitral tribunal in another case involving Italy, the famous Enrica Lexi case, which is a bit more of a complicated case, also involving immunities. But I think these decisions, and let me focus on the Itlos North Star decision, I think this decision is, in my view, misguided, as prescriptive jurisdiction is governed by general international law and not by the law of the sea regime. Enforcement jurisdiction is governed by Article 92 of UNCLOS, which acts here as lex specialis. And I think importantly for our purposes of human rights today, limiting other states, third states, prescriptive jurisdiction would also seriously restrict the opportunities of non-flag states, other states, to address human rights violations at sea. They're not supposed to do that anymore if you extrapolate on North Star, so states which somehow have a connection to a maritime human rights violation, human trafficking, or modern slavery. They can't exercise their jurisdiction anymore, question mark. A state on whose territory a constituent element of the crime, the offense, the violation took place, such as the initiation of the offense, no jurisdiction anymore. A state whose nationals were involved in the offense as victims or as perpetrators, no jurisdiction, it seems, or a state exercising universal jurisdiction, and you know that a couple of gross human rights violations might rise to that level of international crimes attracting universal jurisdiction. So what are the consequences of that decision, that judgment in North Star? Maybe Itlos didn't really realize that this may be a regressive judgment, which is clearly an impact on who can still protect human rights from the perspective of the allocation of responsibilities. Can we always trust the flag states? I doubt that. So I think this is a very bad precedent that has been set and that can hopefully be overruled at one point. But back to enforcement jurisdiction for now. There is this principle of exclusive flag state jurisdiction, but there are exceptions to that principle. Other states may also enforce in some situations. And Professor Scovazzi, you have already referred to an exception in your brief intervention on piracy, which is by some also considered as a violation of human rights as such. This is quite interesting. So I don't know, Anna Petik, what you think of this, but this attracts certainly issues, questions of universal jurisdiction, including enforcement. Now, one can also have UN Security Council resolutions, although the UNSC is quite blocked these days, but in principle, they can allow any state to enforce their jurisdiction at sea. Flag states can also enter into bilateral shipboarding agreements allowing other states to exercise their enforcement jurisdiction. I think, Richard, you referred indirectly to this possibility. We have many of them in the field of drug trafficking. The US is in the habit of entering into deals with Latin American countries, but nothing prohibits also entering into deals in relation to the enforcement of human rights. So maybe that is something to think about going forward. And finally, port states, important role to play in enforcing their laws against foreign flag vessels visiting their ports, also in relation to violations that have been committed on the high seas prior to the entry of the port. There's a lot of practice in relation to IUU fishing, but more and more also in relation to violations of labor law, and then you move closer, obviously, to violations of human rights. Now, there is an exception for matters internal to the vessel, as it is called, but I think it can reasonably be argued that human rights violations do not qualify as such matters, and I think, Natalie, you have also argued that in your piece, and I can only agree with that. If we go to the next slide for a moment, So this is in addition to what I've just described. There may perhaps be some room to exercise enforcement jurisdiction beyond the situations that are recognized by UNCLOS and general international law with respect to stateless vessels beyond mere inspection, although this is, I have to admit, is somewhat contested. So if you read Article 7 of the Migrant Smuggling Protocol, you see a state that has reasonable grounds to suspect that a vessel is engaged in smuggling of migrants at sea. It's a crime, but also a human rights violation. Vessels without nationality, right, so these are stateless vessels. So what can they do? They may not only board and search the vessel, so it's not just inspection, it's more than that. It's to take appropriate measures, but this is not further defined. So what does it mean to take appropriate measures, at least for those states who are parties to the Migrant Smuggling Protocol? Does it also include enforcement jurisdiction in the sense of arrest and detention? Now, the Court of Cassation in this country, the Italian Court of Cassation in the Hani case, was of the view that yes, Italy could take enforcement jurisdiction, and I'm looking at the Italian colleagues, maybe they can clarify that case perhaps a bit more at one point for the audience. And it seems to me that this was based on a combination of the principle of universal jurisdiction and security and protection, which are in fact principles of prescriptive jurisdiction, but they're used here in the context of enforcement jurisdiction. I've been reflecting a bit on that case, the so-called Hani case. I think one should admit that such enforcement may perhaps be legitimate insofar as it gives effect to internationally recognized norms, such as the norm against trafficking, fighting human trafficking. But of course, this is up for discussion. I elaborate on this in a recent publication with Hart, 2023, if you're interested. Now, more radically, I think this is a very radical lex ferenda proposal. We could also entertain the notion that states should be able to exercise forms of universal enforcement jurisdiction over other human rights violations as well. Think about slavery, for instance, or forced labor, not just stateless vessels, but also foreign flagged vessels. I was just reading a piece written by a political philosopher just yesterday saying, well, we have to go beyond the current state of the law if we really want to protect people at sea. But of course, this will require a further nuancing of this principle of exclusive flag state jurisdiction. And if you look at MV North Star, it seems that we're going into the other direction. So I'm not quite sure what the direction of travel is here, but for purposes of protecting people at sea, a relativization of the exclusivity of flag state jurisdiction is of the essence in relation to the whole discussion on flags of convenience. How much time do I have, Mr. Chairman? 9 minutes, that's fine. So I still have some ground to cover in relation to this concept of human rights jurisdiction. I will not tackle everything that I wanted to say because there are issues that will be discussed later today as well. So there is some overlap with the discussion in the afternoon. Let's go to the next slide, and Irini has already told us that it is important that in general international law, the concept of jurisdiction in principle grounds rights or entitlements of states, and Richard has also referred to that. But in human rights law, it's different. Jurisdiction or the extraterritorial applications of human rights treaties grounds obligations of states towards individuals. So this is this relational approach to which Sarah also referred, and here we're talking about a factual or a normative relation between an individual and a state. So it's individual versus state, whereas a classic law of jurisdiction is state versus state. So it's good to bear that in mind, that these concepts are really quite different, but at the same time, both are also addressed today. I think that was the aim of the organizers, to bring people from different epistemic backgrounds together. Now, somehow they could be related as well, so this is also something that I would like to emphasize in the remainder of my presentation. Now, if we look at jurisdiction in the relevant human rights treaties, we find in ECHR Article 1, for instance, a reference to within the jurisdiction, so it's a key concept in human rights law. ICCPR, territory and subject to its jurisdiction, so apparently it's something more than territoriality. So what we learn here is that jurisdiction is broader than just territorial jurisdiction. That's the first takeaway. States may owe obligations towards individuals inasmuch as they fall within their jurisdiction, whatever that may mean, that obviously. Now, this is in keeping with insights from general international law, where forms of extraterritoriality are countenanced and even formally recognized. Now, for the maritime domain, this means that, are we still on slide 4? This means that individuals at sea, and the sea is a largely non-territorial zone, so this is good to be aware of, may potentially, and I say potentially, fall within the jurisdiction of states, and this obviously begs the question when exactly this is the case. And I think the key question for us also for later today, when exactly do states owe obligations, and which obligations are that towards individuals at sea? So let's go to the next slide, and let's start perhaps with the easy cases and leave the more difficult cases for the afternoon then. It's obvious that states have jurisdiction over vessels flying their flag. I mean, we've discussed that at length already, so you could say indirectly they may have obligations, including human rights obligations towards individuals. Article 92, exclusive flag state jurisdiction, and then Article 94 of UNCLOS is quite interesting, goes on to list the duties of the flag state. There is no reference to human rights as such, but there is a reference to social matters, and then I would assume human rights also fall under social matters, and a reference to jurisdiction. Very interesting. Jurisdiction and juxtaposed to control. What exactly is the difference? But still, it's there. Now, whether states comply with these duties, that's a totally different question, but at least on paper, they shall exercise their authority. Now, flag state jurisdiction also means that the flag state, and let's now focus on a government vessel, for instance, a Navy vessel, owes human rights obligations towards persons like migrants who have been taken on board during the voyage, right? This was confirmed by the ECHR in the Hirsi JAMA case, and Professor Treves has already referred to that case of 2012. Now, it's interesting that the ECHR doesn't ground human rights jurisdiction directly on flag state jurisdiction under the law of the sea or general jurisdiction. No, it's based on the exercise of effective control. So that has really become the key concept here. Effective control by a state could be over an area, geographical zone, or in our case, a vessel with persons on board outside the national territory. And here we're talking about direct and not indirect obligation. So this is a standard that is typically used by the ECHR. Reference has already been made to the Bankovic case, the Alskany case, and so on. If we go to the next slide, 6, so our inquiry should then turn to what is control for jurisdictional purposes, and can we perhaps learn from general international law? Now, I believe that there is a productive link here with the concept of enforcement jurisdiction, albeit with a slight twist. If a state mounts an enforcement operation at sea. Now, whether or not that enforcement is lawful, let's now assume it's lawful indeed, and there might even be a duty to mount that enforcement operation under principles of the law of the sea. There may be a presumption of human rights jurisdiction insofar, that's the limiting clause, insofar as the state exercises control over persons during that operation. There are some interesting cases about interception before the ECHR, Medvedev versus France, also women on waves versus Portugal, so interception without boarding can also ground human rights jurisdiction. But the more difficult cases, and I will touch upon them briefly here, the more difficult cases relate to omission and not to commission. So meaning that a state failed to do something that it was supposed to do, for instance, under the law of the sea or under human rights law. The state failed to mount an enforcement operation, although it should have done so, and as a result, hundreds of people die. You know this. So this issue is really brought into very stark relief in relation to search and rescue operations at sea, in relation to rescuing migrants, stranded migrants at sea. The state is maybe under international law duty to mount such operations based on the law of the sea, in fact, but the key question for us then is whether migrants who could have been saved, who should have been saved by a state, an intervening state, potentially intervening state, also fall within the human rights jurisdiction of that state, from duties under the law of the sea or general international law to duties under human rights law. So that's a key issue. Now, to recall, human rights jurisdiction, as I said, requires actual control, which is normally dependent on the actual mounting of an enforcement operation. So arguably there would be jurisdiction in case the state has search and rescue units and facilities on the scene or has given specific instructions to others, private vessels, for instance, present on the scene. So Efthymios Papastavridis has also made that argument a couple of years ago. But in the absence of any physical presence of the state at sea at that very moment, I believe that one would be very hard-pressed to find control and jurisdiction. So these are the very hard nuts to crack also later today. And here enter, obviously, a case that we are going to discuss later today. I'm sure I'm not going to elaborate it on this now. The Human Rights Committee's decision in AS and others versus Italy in Malta. And in that decision, actual physical presence of the state was not required for a finding of jurisdiction. So these decisions have then sparked a lively debate on the limits of jurisdiction, but I have to tell you from a conceptual perspective, as a more doctrinally oriented lawyer, I have difficulty squaring the finding of the committee in those cases with how control is normally conceived. Then we go actually to the last substantive slide, slide number 7. It appears to me that control these days is at times largely constructed along functional lines and comes close to an impact model of jurisdiction. Individuals fall within the jurisdiction of the state because actions or omissions of the state have a detrimental impact on individuals, perhaps regardless of any normative relationship. So what about that? Is it a merely factual relationship enough? Or should there be like an expectation of human rights obligations being owed? Something to discuss later as well. Now, an impact model of human rights jurisdiction somewhat resembles the effects doctrine in general international law, where it has mostly been used in the field of economic and especially antitrust or competition law. But I'm not quite sure whether one can simply transpose this effects doctrine to this very different field of human rights jurisdiction. Now, for one thing, the effects in economic law, the effects are in fact created by the private actor, and then the state exercises authority. But in human rights law, it's in fact the state itself which creates the adverse effect effects by action or non-action, effects on the private actor, on the individual. So it's in a way the reverse scenario. But in essence, I believe that an impact model may make the question of jurisdiction largely redundant. And Alice Olino, who should also be present here, one of the organizers, she's somewhere there, yeah. A great piece, Alice. I think in questions of international law, you have observed incisively, and I'm summarizing a bit your piece, that the arguments that are made conflate the question of obligations and also due diligence, positive obligations, and perhaps search and rescue obligations under international law with the prior question of jurisdiction. So this would then be a logical fallacy. And at the end of the day, just because the state has the power or the capacity to protect rights, because many of the arguments go in that direction, and the state can protect rights, that means it should also protect rights, and it should also have jurisdiction. I'm not quite sure whether this is convincing. Now, where control is used as a relevant concept by these advocates of the impact model, they still refer to control, but this control no longer refers to direct state control over individuals, but it's rather control over organizational policies of the state that could then lead to adversely affecting individuals. So it's indirect, so the question is whether that is enough. I think Violeta Moreno-Lax will say much more about that later today. So I just wonder, I'm not sure, right, whether this nexus between the state and the individual is not too tenuous, not too indirect to validly ground human rights jurisdiction under the ECHR, and I think the same problem arises in respect of the so-called contactless control in SS versus Italy concerning, again, Italy takes center stage. Here again, Italy's responsibility for assisting pullback operations by Libya in the Mediterranean Sea, where again, you need to establish jurisdiction first. Do these people, these migrants fall not just within the jurisdiction of Libya, there's no jurisdiction over Libya, but over Italy, Italy being a contracting party to the ECHR. So this is what they call contactless, not physical presence-based control. We don't know what the ECHR will decide, but that's certainly an issue to further discuss. So ultimately, I think if we espouse such a capacity-based impact model, we may be giving up on jurisdiction as a separate threshold concept. So jurisdiction no longer really exists anymore. And to me, this is in contradiction with the very text of Article 1 ICCPR and Article 2 ECHR, which I projected on the screen earlier. Now, that said, I think things would be different in the absence of a jurisdictional clause. To just give you one example, the EU Charter on Fundamental Rights, for instance, it does not have a jurisdictional clause, which may perhaps mean that you can apply an impact model to the activities of Frontex. And you know, there's a lot of discussion on the human rights, adverse effects caused by Frontex also cooperating with states, but there you don't have a jurisdictional clause in the CFR, so there are some opportunities there. So accountability just follows the activities that you do in the framework of the powers that have been allocated to you. So that's a very different concept. It's closer to a state responsibility or organizational responsibility concept. But about states, it's different. I conclude, my concluding slide is back to the ICCPR, ECHR. You can, of course, try to amend the treaties to get rid of jurisdiction if you don't like jurisdiction, if you see, well, it's a limiting concept that doesn't really protect human rights. You always have to jump over that hurdle, and that's not something that we like as persons in favor of human rights. Now, of course, this is extremely unlikely, and we should also remember in this regard, as Yuval Shani has also pointed out, one of the fathers of functional jurisdiction in human rights, that this limiting concept of jurisdiction was introduced at the time to make the concept of human rights protection practically effective, to avoid creating universal or utopian human rights obligations, for states obligations that are not feasible or are considered as overly burdensome for states. And going by the jurisdictional interventions by states, for instance, before the ECHR lately, it seems to me that states still consider practical effectiveness to be an important value. So it is my concern that if human rights treaty supervisory bodies may stray too far from the preferences of the state, that at one point perhaps they may lose state support, they may lose legitimacy in the eyes of the contracting parties to, for instance, the ECHR, and this could have unpredictable consequences for states' human rights compliance more generally. So I will end on this note, and I look very much forward to the discussion and any questions you may have. Thank you.
Thank you, Professor Ringert, also for having emphasized how much another concept, the concept of effectiveness, has an influence also on the concept of jurisdiction. So if a state is in a position to rescue people at sea and it fails to do so, he is responsible for an internationally wrongful act, for not protecting human rights and in particular the right to life. So now I know that with such a team of experts, the discussion could be as interesting as the presentation of reports. So I am asking Professor Papanikolaou how much time can be devoted to the discussion. 47 minutes. So a long time for the discussion. The speakers have told me that they are ready to answer both easy but also difficult questions. So I invite the audience, and in particular the students, to ask difficult questions to the speakers. So the floor is open. First question.
I start by apologizing for taking the floor first, not being a student. My name is Jacques Hartman. I'm from the University of Dundee. And I would like to ask all the speakers, and thank you very much for very interesting presentations, but I would like to ask you a slightly provocative question, and that is whether or not you think jurisdiction is a useful term, and whether you actually were speaking about the same thing. Because if we take Irini's starting point about legislative powers, enforcement jurisdiction, and adjudicative powers, then I'm not sure that all of the zones that Professor Barnes were talking about falls within that definition. Professor Seck talked about extraterritorial jurisdiction, but if we apply the standard kind of rules on jurisdiction, most of what's called extraterritorial is actually not, at least not extra-legal, and it happens quite a lot, especially with, for instance, active personality principle. And then to Professor Ringart, I was wondering, you did mention a critique, why didn't the European Court of Human Rights apply just the flag state jurisdiction, which would seem much simpler. But isn't it even more strange that it applies a principle of control to say whether or not there's jurisdiction, where normally under international law we will say, well, is there jurisdiction so you can exercise control? It seems to have turned the principle of jurisdiction a little bit on its head. And it could have applied standard principles of international law to say when states have human rights obligation. So that was quite long, but I'll just add a little thing to it. Maybe also one of the problems what we have when we talk about human rights is that traditionally we talk about limiting state spheres. So Rosalind Higgins talked about everything else would be rancor and chaos, so we couldn't say when one state's sphere ended and another state began. So we have this kind of limiting understanding of jurisdiction normally. But when we talk about human rights, actually what we don't want to do is to limit states, but we actually add extra obligation. I was wondering that creates an extra complication when we're talking about human rights and jurisdiction the way we do today. Thank you.
Yes, I'm very satisfied because we have a set of difficult questions addressed to all speakers. So, ladies first, Mrs. Beck, and then we will proceed with the other speakers.
Okay, there. Thank you. I'm not sure I say thank you to let me go first, but we'll go from this. So I will note, I framed the presentation with reference to extraterritoriality because it has been very clear to me in my work that this is a word that is used a lot, thrown around, and yet it doesn't have a clear definition, and its use is inhibiting because it right away sends the message that you can't. And you can't because, and I think the important message, or where the focus should be, is not on the word extraterritoriality, but on the question of sovereignty infringement and what does that mean. And so I note in the human rights context, of course, as I was doing this, the Maastricht principles on the extraterritorial responsibilities of states came out, and I've had a lot of discussions with them about, is that really the word you should have used? And the consensus has been, maybe we should just say the responsibility of states and not have any kind of qualifier because it is confusing and it isn't helpful. So I think we are talking about jurisdiction. Perhaps. but what I will say is where I think the conversation should go and where I didn't sort of get to is there, and perhaps in the law of the sea context, this is sort of really in focus with this idea of exclusive jurisdiction of flag states. This discourages conversations about duty to cooperate, shared responsibility, which I think are really important. And so as a just throwing out the idea, if I think of the business and human rights context and the responsibilities to conduct human rights due diligence, how is it that a company can take this seriously in light of the challenges of enforcement jurisdiction on a flag state? Well, maybe companies should require agreements to be in place to enable other states to take up their shared responsibility when it comes to exercising enforcement jurisdiction. I mean, that might be one sort of, idea sort of out of the box to try to overcome perhaps the challenges of the exclusive jurisdiction model and to draw us into the conversations that I think are more important about shared and cooperative exercises. And the last thing I'll sort of note is that at least it's important, I think, to say that I very much am a legal process theorist. So I also think when it comes to the extraterritoriality kind of conversations, that what's most important is to think about if a state, decides that it is going to take on a responsibility and act, it's not helpful to think, well, could they have done that, or should they have done that, or whatever. The question is there a response? Has another state responded and said, whoa, that's too much, you've infringed my sovereignty? Have those whose human rights are at risk have they benefited? Are their rights better respected? So I think seeing it as a process is also an important part of the conversation. And I'll stop there. I probably didn't answer any of the question, but.
I think your remark related to my remark in relation to Hirsi Jama, where I said that the ECHR does not grant human rights jurisdiction directly on the concept of jurisdiction. exists under the law of the sea, flag state jurisdiction, or general jurisdiction, but they refer to the exercise of effective control then in line with the earlier cases. Yeah, indeed, they could have referred to Article 94 of UNCLOS, but I think the court was very much concerned about the coherence of its case law on human rights jurisdiction, starting with Bankovic Alskani. Alskani was actually the year before Hirsi Jama, where they refer to effective control. So you see a further and incremental development here in the maritime domain. I think this was the very first case in the maritime field. By the way, maybe there is some confusion here. We are not talking about effective control in the sense of Article 8 of the Articles on State Responsibility here, which is control for the purpose of attribution. So here I'm talking about control for the purposes of jurisdiction. Control under Article 8 RC was actually connected to state responsibility in the issue of a breach being attributable then to a state, an issue that for me arises after jurisdiction has already been found. This is at the level of has a breach actually occurred that you can somehow impute to a state. So there are two different forms of control, you could say. Control for jurisdictional purposes, which is really a threshold issue, and then we're talking about a proximity between the state and the individual. I want to emphasize that again. A relationship. Is there a relationship between the state and the individual? A normative relationship which creates legitimate expectations on the part of the individual that the state will protect his or her rights, which is a big issue, of course, in relation to migration at sea. Is there a legitimate expectation of a migrant setting sail from North Africa to Italy, for instance, that Italy will protect the rights of the migrants? And then you can talk about a normative relationship grounding human rights jurisdiction, even under a contact-less control model. But this is really contested. The short of the matter is that there are two different.
And the kind of justifications for jurisdiction is that if you look at these from first principles, you think about, well, why do we give flag states jurisdiction and why is it exclusive and what's the rationale for that? Now, one rationale might be because it's simply an ordering function. But what we probably do, and I've kind of really struggled with flag state jurisdiction to look at what the kind of underlying justification for this is, because it seems to lack a kind of like set of normative or moral principles. And that's kind of problematic for me because the ordering principle there is a kind of neutral one, and it operates as a barrier to other kind of things happening. So, I mean, we do have kind of exceptions. So we have, for example, slavery. We're talking about this briefly this morning. And if, for example, there is an awareness that slavery is occurring on board a vessel, there is at least a mechanism to challenge and penetrate that jurisdictional veil. And I guess that the point for me is if we come back down to kind of first principles and think about what is the kind of thing that we're giving authority for, and is the state failing to exercise that, then does that open up at least a moral or political basis for then challenging the legitimacy of the legal framework and looking at changes? And I think that's really important because the way in which jurisdiction tends to evolve here is almost on a kind of an ad hoc basis, a kind of doctrinal basis, and it pays too much homage to existing kind of rules and principles. So if they're not working, we have to kind of step back, evaluate them, and then kind of challenge them. So it's just providing that. So that's a kind of long way around to say that, yeah, flag state jurisdiction is a problem. Sorry.
Professor Ringer has something to add.
Thank you very. Oh, sorry. Maybe Irini, you first. Yeah, so limits to jurisdiction, I take that question as you have jurisdiction, but you may not want it or cannot exercise it to the fullest extent as it is given by the law. I've spent part of my career thinking about that, about limiting the exercise of jurisdiction, and I came to the conclusion that perhaps we can use certain general principles of international law to limit overbroad assertions of jurisdiction. Think about the principle of reasonableness, for instance, the principle of comity, non-intervention, abuse of rights, and other regarding this. And this is, in the end, also about limiting power. And here I would draw the link with what Sarah Seck was explaining about inequality and power in international relations. A 12 perspective, this all has an impact on who can exercise and who does actually exercise the enforcement jurisdiction at sea. If we agree that we need more enforcement at sea, for instance, the proposal that I formulated, more universal enforcement jurisdiction over slavery, but also over other human rights violations, not all states are going to do that. Some states are going to do that more often than others, and it might serve their purposes and not necessarily the purposes of human rights. It may not serve common interests. So there is this distinct possibility of abuse of a jurisdictional right that is then given by international law. So the key question for me is whether we can trust the first movers, can we trust the powerful states not just to pursue their own interests, but also to act in the common interests and to actually protect human rights. So that's a question that is out there, and I don't have a clear answer to that. So you can have some constraining principles that they have to act in a transparent way and motivate why they do something. At the same time, there's the big issue of under-enforcement as well that we have to be aware of. There's no question of over-enforcement, and I think Professor Scovazzi also referred to that in relation to piracy. There are no positive conflicts of jurisdiction, but negative conflicts of jurisdiction. No one is basically assuming their responsibility. So talking about limits to jurisdiction, that's just fine, but I would also like to talk about obligations and responsibilities to exercise your jurisdiction. And I think Richard also referred to that. There is the shift in jurisdictional doctrine from entitlements to obligations, but then the question is whether the obligations are properly discharged. There are typically, clear monitoring bodies to check that. Flag state jurisdiction is one major issue in relation to human rights violations, with the flag state simply not assuming its responsibility. What are you going to do about that? Set up an international body to enforce human rights at sea and to do some spot checks of vessels flying the flag of other states? I'm not quite sure. You can really think out of the box. But I think more needs to be done in terms of enforcement, which has always been the Achilles heel of public international law.
Yes, please.
There, just to add, I agree with everything that's been said, and I think it's interesting in the human rights context because if we think back to at least my reflection that the real question should be, do other states object to the exercise of jurisdiction? Then I think in the human rights context it is quite interesting. Like, who would object to, another state stepping up to protect human rights? And in what context would that happen, and what does that mean? So I think there's a tendency to, and again, this may come, there is a contextual piece to this. This may come from being Canadian, right? Going back to my initial slide, in conversations with government officials about, well, why can't or shouldn't, Canada be proactive in this ways? The response always was, well, we can't do that because that's what the US does to us all the time. And so that's not Canadian of us to do this, right? And I think the response to that is that sort of idea is a problem. Like, the fear of infringing sovereignty seems to prevent some states from stepping up and taking on responsibilities. And so I think your question is, are there real limits? And I think there are really two questions. One is, are there real limits? And maybe there's something to do with flag state exclusive jurisdiction. But the other one is, do states believe there are real limits that actually aren't there? And how can we help them to overcome their perception that there are real limits? And I think in that case, it's encouraging them to take those steps, and in the human rights context in particular, to see what other states say. Maybe there are ways and times when the exercise of support for human rights does infringe state sovereignty. And I can, in the transnational economic context, I can give examples where that could come up. But I think that's where the focus, I think again, there's sort of two pieces, right? Is like, what do states believe, even if there isn't a rule? And where is there actually a rule, and how can it be overcome?
I have two other questions, then we stop the questions because of reasons of time. Please.
Yes, Stephen Haynes from the University of Greenwich. I'm not sure that I'm going to be asking a question. It's more of a comment, really, about the issue of exclusive flag state jurisdiction, particularly on the high seas. And the issue also of effective control, because it is my contention that there is not a single flag state globally that is capable of effective control of its vessels on the high seas. And I grapple with this particularly in the human rights at sea context. I'm a trustee of the NGO Human Rights at Sea. And the whole business of law enforcement on the high seas is a real issue and a real problem. I'm a former naval officer as well, and I spent all of my operational time on law enforcement operations. And so I tend to look at these things from a very practical point of view, as well as from an international legal point of view as well. And the sheer practicalities of enforcing any sort of human rights standards on the high seas is intensely problematic. And it really does need to be addressed. I don't know how we can address it. I'm a rationally disposed sort of individual, and I look at the political problems associated with changing the whole attitude to enforcement jurisdiction. And I'm not sure, and Sarah, you just mentioned a second ago, who would object to somebody exercising, I can tell you now that most flag states would object to other states taking that sort of initiative on the high seas. As I said, I'm not really asking a question, I'm simply highlighting a major problem. It's sort of the elephant in the room in jurisdictional senses as far as I can see. The whole issue of exclusive flag state jurisdiction, the genuine link, for example. What do we mean by that? What is the purpose of it, and how is it effectively implemented? Where do we take responsibility? And if there's a shift from a right into a responsibility to enforce, then I think we've got to really start addressing that fundamental question. Thank you.
Thank you very much. You have made more considerations than asked questions. Yes, I take on board two more questions, then I will give the floor to all the speakers. Please.
Thank you. Right, so we keep talking about the importance of reading the law of the sea in conjunction with human rights law. And Professor Travers says earlier this morning that these two legal regimes found a point of contact. And at the same time, we're desperate for case law. I mean, we keep going back to the same cases. There is only a handful of cases that deal with human rights at sea. But the problem is that the jurisdiction of the courts does not allow them to do so. So, for example, we have ITLUS that has come across cases that touch on human rights issues, but they cannot engage with human rights law because their jurisdiction is the law of the sea. And then we have the European Court of Human Rights that its jurisdiction is about human rights law and the European Convention, not about the law of the sea in UNCLOS, or the Human Rights Committee. I think the problem was very obvious in the AS decision, the Human Rights Committee. They really struggled there to bring together search and rescue issues, right to life, but this wasn't right. I mean, the dissenting opinions are very clear that this is law of the sea. It's not human rights law. So I guess my question is, I mean, what could be the solution to this problem? I mean, we need jurisprudence. We need to study these issues together, and we cannot do this when it comes to courts. Do we need more proactive judges? Do we need a new body that will study this issue? Do we just have to accept that this is the way forward? I mean, Or do you think that this is not a problem at all? And as an add-on, I mean, in my view, it's also problematic that the people who sit in these different bodies, they can't know everything. I mean, the Human Rights Court, I'm not sure how many people have actually a background on the law of the sea. Or when you go to ITLUS, how many of the judges they actually have a background in human rights law. And yeah, I think this is a problem. I don't know if you have any ideas, any comments on that point. Thank you.
You asked the floor, yes, please.
Thank you. I'm Maria Luisa Deftu from the University of Athens, and my question draws from the last point, actually, of Professor Ringert about legitimacy. So I was thinking about the extraterritorial jurisdiction mostly, which is in nature exceptional. However, we have witnessed during the latest decades an expansion of the application of extraterritorial jurisdiction across human rights bodies mostly. Of course, we need this in order to enhance human rights protection. But at the same time, we have witnessed a backlash to these bodies as well. For instance, let us think of how complex the jurisprudence on extraterritoriality before the European Court has become, not only in the maritime domain, but in general. For instance, Georgia versus Russia. This is just an example. But also the backlash before the Inter-American Court of Human Rights. Before the European Court, again, let us think the recent voices raised in the UK regarding migrant deportation flights back to Rwanda. And of course, the latest point made by Sofia and by you, of course, about the Italian cases before the Human Rights Committee and these new concepts of proximity, causality, and the role that they play. Also, the new, the European Court struggles with the concepts of jurisdictional link. Do you think that this complexity when it comes to extraterritorial application of human rights at sea contributes to the legitimacy crisis of these bodies, if any? Thank you.
Thank you. So I have noted on my papers 51 questions. Professor Ringert has 1 question. They will be lost forever because in the interest of future generation of speakers, I must give the floor for 1 minute for a concise answer to every speaker. So we have more time. So 15 minutes, please.
Okay. Let me respond to a few thoughts. First, Stephen, absolutely, of course, flag states will protest. But I think my comment is I think that a lack of human rights protection action is based over fear of protest, and perhaps we should be less fearful of protest and have a deep conversation about what is the protest about. And this, I think, goes to a key point here, right? Another state is not going to be engaging in enforcement jurisdiction on a ship to, support the protection of human rights if the flag state is doing its job. If the flag state is not stepping up and taking responsibility to ensure that human rights are being enforced, then the question would be, why? Are they lacking capacity or are they lacking will? If they're lacking capacity, then what can be done to better support them so that they have the capacity to do this? Or to ensure that there is, a rich conversation about shared responsibility and other states being able to step up. So I guess my sense is absolutely, let's get those protests happening when it comes to human rights protection so we can have a meaningful conversation about what needs to be done so that the human rights are protected. That's an easy and glib answer, which is probably not satisfying, but that's sort of where I would go with that. Just on the different bodies having different understandings. Of course, I'm coming at this from a business and human rights perspective, and I will say that my earliest work was in the area of mining and extractives, and there is extensive guidance out there for businesses in the mining and extractive sectors on how to engage in human rights work. There is not comparable guidance and thought that has gone into the shipping industry, for example. The IMO does lots of stuff, but human rights is not one of the things it does in that way. There are other bodies that do select pieces, but I think there's a lot more work that needs to be done to clarify for businesses, and therefore the shipping industry and others, what it means to take human rights seriously. And then finally, judicial education in so many areas is a necessary thing, and maybe there needs to be judicial education for many bodies on these other areas as the potential of cases increases. Thank you.
Thank you for your question on legitimacy and the expansion of extraterritoriality, which is a legal but also political question. I believe, could it lead to a backlash against human rights, especially in the domain of migration, I think, where we clearly see that right now. Imagine that the UK decides to leave the ECHR, which is a distinct possibility, very concerning. Imagine that Italy leaves the ECHR, so then you are worse off from a consequentialist perspective. So think, and I think judges think about that. What are the potential consequences in the political domain if we go too far? So in the end, as Koskiniemi said, indeed, it's international law is between apology and utopia, and it's walking really a tightrope where you don't just want to give effect to state preferences. That's not what you want to do as a human rights court, for instance, but you cannot stray too far either from the preferences of the state. And I say that especially in the migration domain. I mean, I come from the Netherlands, and you know there that parties running on an anti-immigration platform won big in the election. So you can see that as a sort of backlash against liberalism, against human rights, and permissiveness in the migration context. I don't agree with that, but it's a reality that we need to take into account from a legal political perspective. So thank you for bringing it up, and the judges have their work cut out, obviously. I'm glad I'm not a judge.
Just to come back to Stephen's point, I kind of agree there with the kind of general point you make. I guess to further complicate things, I guess the reason why we have things like substandard labor and labor abuses at sea is a kind of consequence of our kind of global economic trading system and markets. So we want cheap, regular food stuff, which drives the price of goods down, etc. And so the problem of dealing with human rights abuse at sea is treating the symptom rather than the cause, but that doesn't maybe help our current discussions because we maybe can't solve those. So we're looking for what the kind of practical interventions are in that kind of context. And on that point, I guess I agree. Things like R2P, responsibility to protect, have been problematic. So where states fail to act, other states step in, is really challenging. So, but there are kind of other jurisdictional mechanisms, and so kind of improvements in port state control, port state inspections are potentially a way of doing this, and we can see how that might work. But the risks there are that it just kind of pushes the problem around the planet, and it puts the kind of problems into states who are at least able to deal with these challenges. But, well, I'll leave that one there. On the point about kind of judicial courts and case law, I'm never entirely convinced that more cases is a kind of good thing. So I'd be kind of cautious about that, I think. Sorry, Elizabeth? You want more cases? Okay, yeah. Only if they're decided the right way. And at least I'll say, we talked about the North Star case. You're on the right side of that one. But that's a kind of a challenging case there because the majority decision kind of limited, in a sense, the potential for enforcement action, which I think is problematic given everything we've kind of discussed there. So, but I think the kind of key thing are that there is a lot of interest now in kind of terms of strategic litigation, the idea of generating case law specifically to kind of raise these kinds of issues, but it's costly, it's expensive, and it's kind of retrospective, and it doesn't really deal with the kind of prescription of the standards that we need to look at. Sorry. I think my cough's telling me to stop talking, so I will.
So only now I realize that the second session of this conference will take place after lunch and not before lunch, as I believed. So we still have more time. So my 51 questions and the question by Professor Ringert could be asked, but yes, you have a question, please.
Good morning. I wonder how and if sea jurisdiction could be affected by the growth of climate immigrants and climate refugees, or do you think it won't be touched?
Could you repeat the question? Because
I wonder how and if sea jurisdiction can be affected by the growth of climate immigrants and climate refugees, or do you think it won't be touched by this issue?
so if the problem of climate refugees can have an influence on the question of jurisdiction.
So I was invited here to speak about the corporate aspect, and of course, the climate migrant aspect is not specifically corporate related, but I have thought a lot about and co-edited a book on climate loss and damage, so and human rights. So I'm sort of have been reflecting on this question as the panel sort of unfolds. I think it's interesting, and the climate regime as a whole has been not as engaged in human rights as it embedded in human rights issues as it should have been, and so the way in which many different areas of law sort of speak to the gaps that have been left by the climate regime, I think, is an important piece. I would hope that it would affect and would change how jurisdiction is thought about. And I think going back to trying to think, I've been trying to think this through during the panel, sort of from a relational perspective, how might this affect how we think of sort of the migrant challenge. But I think certainly to the extent that migrants are migrants because of climate harms that are making it impossible for them to live where they would otherwise want to live. There are other responsibilities or other states that have responsibilities to address loss and damage for climate change and implications for human mobility that are conversations that need to be had and should therefore influence where the jurisdictional conversation goes. So that's not an answer, but I think it's a great question, and I think there's a lot that needs to be said so that this isn't seen as, so that when migrants are at sea, this isn't seen as just a law of the sea or just a human rights question, but also relating to why are those migrants at sea? What are they leaving? What has motivated them to leave? And who has responsibilities in relation to that should therefore also be part of this conversation?
Thank you, Sarah. To add, perhaps climate migrants, immigrants may also use the sea, of course, to come to Europe. So you see clearly the issue of jurisdiction at sea, an issue that is central in the case that is pending, and very soon a decision will hopefully be taken, SS versus Italy. And I think many of these migrants may perhaps also flee certain climate-induced conditions in Africa or other parts of the world. What we also see is outsourcing, processing deals between, for instance, the EU and countries in Africa, the EU-Tunisia deal, for instance, that's regardless of the law of the sea issues. But the question is then, who is responsible when something goes wrong? That has become a very big political hot potato these days, the deals struck between EU and EU countries. Also Italy and Albania, for instance, has a very interesting deal with, as I understand, some type of enforcement jurisdiction even of Italy in processing or detention centers on the territory of Albania. So we would really need to look at that from a jurisdictional and responsibility perspective. That's more general, but more migrants might be coming, whether it is climate-induced or conflict-induced, and climate can have and can affect also conflicts, as you know. So everything is related. Thank you for your question.
Please.
I'm sorry, I don't know if what I'm about to say is going to make any sense. We're talking about jurisdiction, we are talking about courts, and what the lady was saying earlier on about...
Can you speak louder, please, and at the microphone?
Okay. What she was saying about jurisdiction in the courts, how some see, law at sea or migrant law or human rights law are so often complicated. My question is, we are now seeing a lot of numbers of people migrating for, let's just say, climate change. We are seeing a lot of people who are migrating or losing their countries because of corporate greed, and so maybe mine is more an issue more than anything else. But the question is, how can we expect jurisdiction and legislation to change when right now the people who are responsible to make a change, so legislators, governments, are, for instance, plotting the deal between Albania and Italy? It's like, right now we have this type of situation, a lot of countries and governments who are shifting right. So what is making me think about the legislation of the sea, how to save human rights, how to help people at sea, when in fact we have governments just saying, oops, not my responsibility. Did you drown? It's your responsibility. You should have stayed home instead. So how can we expect the European courts to actually start making legislation? The same goes for the United States and Canada. We would love to help, but it's not enough Canadian. And in the meantime, you just look at the United States building walls and just watch people die. It's not just the sea, it's global. It made sense, sorry.
Okay. A starting point for me in the business and human rights context is an expectation that states violate rights. We should expect states to violate rights. In fact, that's why we have international human rights law, because states violate rights. We would hope that they don't violate rights. We would hope that there are good governments, and we're in Canada sitting next to the US and really hoping Trump isn't the next president there, and who knows what's going to happen with our government. So we would hope that we would have good governments that would believe in human rights and would respect rights. But we should start as a starting point with an expectation that states will not always and will not respect rights. Now this creates a problem for law, because we as legal educators train our students to work with their clients on respect for law. And that generally, at least in the Canadian context, means respect for domestic law. But what if the domestic law isn't good enough? What if it isn't up to international human rights law standards? And we need to think, how do we understand international human rights law from the perspective of those whose rights have been violated, right? Like, so international human rights law may not always be good enough, or interpretations of it may not always be good enough. But I think this is why it's really important to see states as not the only human rights duty bearers, to think expansively about human rights duty bearers, and certainly in my work that means including business organizations, but it actually includes all organizations. And so deeper and richer conversations about the role of non-state actors, both as rights holders but also as duty bearers, I really think is an important part of the human rights conversation. And I think it's the only piece that for me sort of gives me the hope that we can figure this out, right? That everybody needs to step up. This is not just about states. We need courts to the extent we can use courts, but courts are limited. And sometimes courts are problematic because they think that unless they've issued a decision on it, there is no law. Certainly the Supreme Court of Canada does that, and it's really problematic. It's like, you guys aren't the only ones out there. But so I think we, embrace courts where they're there. We're not part of a regional human rights mechanism in court, and I wish we were, but we're not. Embrace courts where we can, but it's all duty bearers stepping up and supporting, and that's all we can do.
I think what you're referring to is this shift towards the externalization of migration control. So basically you push these people away from your borders outside the EU, and the ultimate goal is that you don't meet them anymore. You don't meet them at sea anymore because they never get to the sea. So this is why you enter into all those deals. And if you don't meet them, there is no encounter, there is no jurisdictional link, right? And then there are no obligations. That's how the logic works in terms of externalization of migration, unless you go for a concept like contactless control. And this is the argument in this case of SSR's Italy, to which I referred. So it's based on cooperation with third states, and indirectly you still encounter those people, not directly. It's Libya or a state in Africa, for instance, encountering the people, but you support those states financially, logistically, via training and so on. And perhaps on that basis, you should be held responsible. But again, responsibility is different from jurisdiction. So that is the issue. First, you need to establish this jurisdiction, and then you will discuss responsibility. Because I believe there is responsibility, aid and assistance under the law of state responsibility. But first, you need to clear the hurdle of jurisdiction, and that's the clear and present challenge right now. Thank you.
So, now I have a message from Professor Ringert. If no questions, I have questions in plural for the panelists. I have still my 51 questions pending, so I take the irrevocable decision that all the pending questions will be lost forever. And I thank the panelists for their presentations and their participation in the discussion. I thank the public for their participation too to the discussion. And so the session of this morning is closed.